I guess to start out, my first appearance in Judge Dugan's courtroom, I filed a complaint against Scott Hall for legal malpractice. The defense filed a motion to dismiss or a motion for a more definitive statement. So Judge Dugan explained to me, even though I was representing myself, I still had to adhere to the rules of civil procedure. And this is what the appeal is all about, adherence to the rules of civil procedure. In the defendant's appellee's brief, they claimed 14 times in their brief that I failed to comply with the rules of civil procedure, and that I must comply with the same substantive and procedural rules that represented parties are expected to observe. That was page 19 of their brief 3 times. And they go on to state that the rules are not overly complex, contain language understandable by laypersons and attorneys alike, and plainly use mandatory terms like shall and must. Now, all throughout the proceeding, the defense failed to comply with the rules. Their response to the complaint was filed late, and there was no motion for, I forget what it's referred to, motion for expansion. I'm sorry, I can't think of the term right now. And the same thing when I went back to court. And by the way, the second appearance in court, there was an agreed upon order. I received an email from the defendants. There was an agreed upon order that was never filed. I was completely unaware of this until I looked for it in the record when it was sent to me when I filed this appeal. I have no idea why it was never filed. But then we went back to court. I'm sorry, I'm fumbling along with this. I'm doing my best. We went back to court, and the judge dismissed all but one part of my complaint, and the defendant never filed an answer. And this went on for a month and a half. So I filed a motion for summary judgment. Only then did the defendant file an answer. So we went to court for the motion on summary judgment. They filed a response to the motion for summary judgment with the court, but it was incomplete. It did not contain Exhibit A. And it was not properly served because it was not a true and exact copy. It didn't contain the Exhibit A. Exhibit A was, if I'm not mistaken, a request for discovery. And in their brief, they were claiming that the defendant had outstanding discovery to be answered. Then they claimed the plaintiff had outstanding discovery to be answered. So without Exhibit A, we have no idea what was going on. So when we went to court to hear my motion for summary judgment, it was dismissed because I didn't follow the rules. But do the rules apply equally to both parties? Because the plaintiff still has yet to follow the rules. There's been no motion to enlarge the time for their, a motion for enlargement put before the court for either responding to the complaint or answering the amended complaint. Now, I understand that from what I've read, the courts like to see cases decided on the merits. So they will extend the time for, I believe it's called excusable neglect. Excuse me. But at what point does neglect become inexcusable? Is it once, twice, 3 times? So the defense has neglected this case 10 separate times. 5 times, and they've done the exact same thing twice. They were late filing their response to the complaint, then they were late filing their answer, and both times they still haven't filed a motion for enlargement with the court. They sent out a motion and a counter complaint without Exhibit A attached. According to the rules, any exhibit referenced becomes part of that motion. So they failed to file Exhibit A twice. They failed to properly serve these documents twice because there was no Exhibit A when it was served upon me. It was not a true and exact copy. And twice they failed to file an order from the court. I had submitted a motion to the court to I can't think of the word right now, have that order, a proposed order added to the record, amend the record. The main reason for that is, number one, I didn't even know it wasn't submitted. I was totally shocked when I looked at the record and it wasn't in there. And second, in the motion, and I believe the email correspondence was in that amended record, the judge refused to hear any oral arguments on my motion for summary judgment. So none of these issues could be raised with the court because he would not allow any discussion on the matter. Now, the defense has had 3 full years to comply with the rules to enlarge the time for their late filings, and they've chosen not to do so. So they've not complied with the rules throughout this entire procedure.
Did you file a motion for default judgment?
Oral motion in the court.
Okay.
It was not properly filed, I agree, but it was, I was shocked that the judge refused to hear any arguments in the case, and I was prepared to fumble through an argument like I am today, at least to try and make my point about the defense not following the rules, but there was no oral arguments allowed on the hearing that day. I believe that's all I have for right now. Thank you.
That's fine. You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
This is a legal malpractice matter that arises out of...
Please introduce yourself, please.
Oh, sorry, Your Honor. Scott Hickerson with Lowe, Yeager, and Brown. I represent the defendant appellee, Scott Hall.
Thank you.
This is a legal malpractice matter arising out of Mr. Hall's representation of Mr. Boesch in the trial court for the Chancery Court of Sevier County. That matter went to trial before the Chancery Court, and there was a judgment entered in Mr. Boesch's favor. However, Mr. Boesch was unsatisfied with the result and ultimately sued Mr. Hall. Upon receipt of the complaint and timely, Mr. Hall, through counsel, filed a motion to dismiss or for a more definite statement. That was within 30 days. The issue was heard, an amended complaint was thereafter filed. A second motion to dismiss was filed. That too was heard, and the court dismissed 2 of the 3 causes of action. After that, the parties did enter into discovery, and at some point, Mr. Boesch filed a summary judgment motion, allegedly under Rule 56, but it did not contain a 5603 statement of material facts. And so the court denied the motion for summary judgment that Mr. Boesch filed on that grounds. An oral motion for default was thereafter made, which was also denied by the trial court. The matter then proceeded to the point where the defendants filed a motion for summary judgment that was properly supported, did contain the requisite 5603 statement of material facts with citations to the record and an affidavit from Mr. Hall in support as well. That was thereafter granted by the trial court, and Mr. Boesch then filed the instant appeal. We ask that the court affirm the trial court's rulings, both with respect to the denial of Mr. Boesch's summary judgment motion, as well as his oral motion for default judgment. As the record makes clear, the motion for summary judgment was deficient. It did not contain a 5603 statement of material facts. It did not cite to the record, and the court was well within its discretion to deny that motion for summary judgment on the procedural grounds and the failure to comply with Rule 5603. And the case law, including those that were cited in the appellee's brief, Rye versus Women's Care Center of Memphis, as well as simply the rules themselves, touch on the issue that we're here on and why the summary judgment denial should be upheld. Specifically, the Supreme Court stated that a moving party seeking summary judgment by attacking the non-moving party's evidence must do more than make a conclusory assertion that summary judgment is appropriate on the basis that's being presented. Rather, the court said, Tennessee Rule 5603 requires the moving party to support its motion with a separate, concise statement of material facts as to which the moving party contends there is no genuine issue for trial. Mr. Boesch's Rule 56 motion was not in regards to any material fact on the underlying claim. It was simply that there had not been an answer filed after the court had dismissed 2 of the 3 causes of action that he had asserted in his amended complaint. The failure to comply with the rule in the Supreme Court's prior holdings, and that it is not a summary judgment motion that this court would normally hear on a de novo basis, but because it was based upon procedural grounds, it's discretionary, and the court was well within its discretion to deny the summary judgment motion. So
Mr.
then when
Hickerson,
Yes,
as
ma'am.
to the oral motion for default, at that point, had an answer been filed as to the remaining claim?
It had, Your Honor.
It had.
It had. So when the summary judgment motion was filed, came to our attention, the answer was promptly filed. I believe it was within days, 2 days, I believe. An answer was filed, and then a response to the summary judgment motion was also filed. And with respect to the motion for default, that too was deficient under the rules, which requires written notice. And so the court was within its discretion to deny it solely on those grounds. But as far as the court's preference for deciding cases on the merits and moving forward on the actual claims presented, that's what we were doing. And Rule 55 is clear on its face that it is discretionary, that the court may grant a judgment of default if there is no answer or the party otherwise fails to defend. And here, Mr. Hall was clearly defending the claims against him. His attorneys had made an appearance. They had moved to dismiss not once, but had moved to dismiss twice. They had entered into discovery with Mr. Boesch. There had been discovery served on him. He had served discovery on the defendant. And so this is not an instance in which the lawsuit was served and ignored. There was no intentional delay on Mr. Hall's behalf. We were actively defending the claims that were asserted when this motion came to our attention. And this may just be me, but I'm not sure that Rule 12 is clear when this scenario actually happens, where the motion to dismiss is actually granted, but only in part. Is there to be an amended complaint that articulates the remaining claim, or is the defendant supposed to come in and they're filed an answer based on what he believes the complaint is alleging based upon the only cause of action remaining, which facts are relevant, which facts aren't? Here, as soon as we realized that there was no answer, one was filed, and it was filed, Your Honor, before the oral motion for default had been requested.
So the answer was filed before the oral motion for default?
Yes, Your Honor. The only other point that I would make, Your Honors, is that this appeal is with respect to both the denial of Mr. Boesch's motion for summary judgment and Mr. Boesch's oral motion for default judgment. He did not challenge the summary judgment granted in favor of Mr. Hall, and so to the extent that that was not addressed, it was not argued, we would suggest that that has been waived and that any other arguments would be moot. That's something that's addressed in our brief. The issues on Rule 6 that Mr. Boesch has raised were not addressed at the trial level. But again, with respect to when service was actually made of the initial complaint versus when the original motion to dismiss came in, all of that was initially timely. And so on the merits, the court was correct in its rulings. We ask that this court uphold both the order denying Mr. Boesch's summary judgment motion and the order denying his oral motion for default.
We'll hear from you, sir, in rebuttal.
Okay, first off, the response to the complaint was not timely. It was most definitely not within 30 days. That's, of course, in the record. I'm sure y'all have copies of that. According to the rules, if there's no response to a motion for summary judgment must be granted, according to the rules. If the response is not properly filed and properly served, does the response actually exist? Is it?
Is that what you were talking about, was Exhibit A wasn't attached?
Correct.
All right. Was Exhibit A ever furnished to the court?
Not that I'm aware of. In either instance, in their response to the motion for summary judgment or in the or in their counter complaint.
So the court didn't have Exhibit A or whatever it is in front of it?
Correct.
Okay.
And nor did I, of course. And that's one of those words that the defendant said, words that are easy to understand, mandatory words like must and shall. Now, as far as the claims being undisputed, if there's no answer properly filed, then there's no dispute. Their answer was most definitely not timely filed. Once again, it's in the record. It wasn't a day or two late. I believe it was, and the rules are kind of iffy on that, or hard for me to understand on that. When the way I read it, with their motion for a more definitive answer, once that part of the complaint was affirmed by the judge maybe, or part of it was dismissed, part of it wasn't. I can't understand if it's just 15 days they have to file an answer or if it's actually the full 30. It's kind of strange in the rules the way that read. But in either case, if it was 30 days, they were 20-something days late, and only in response to the motion for summary judgment. So neither one was timely filed, especially the original response to the complaint, like Mr. Hickerson claimed. It was most definitely not timely filed. Now, as far as the defendant's motion for summary judgment, if the rules were applied properly in this case, would it ever have gotten that far? Should it ever have made it to the point of their motion being filed? I don't believe so. When somebody like me walks into a courtroom, can't afford an attorney, don't want sympathy for it, it's just a fact, I'm already at a disadvantage. So I'm trying a case and it's like I have one hand tied behind my back already, just walking into the courtroom. Now, when the rules are rigidly applied to me, but not to the defense, that's like tying both hands behind my back and blindfolding me. It's not a level playing field. There's virtually no chance of success. So the rules should be applied equally to both parties to make a level playing field. And that didn't happen in this case whatsoever. And I'd like to stress again, as far as any issues being waived, if there was no chance to bring the issue up to the court, how can it be waived? That would be like any argument I make today. If I was going to come in to make an oral argument today, and you judges didn't even listen to the argument, and then later said, well, you didn't argue it, it was waived. Well, how can it be waived if I wasn't given the opportunity to argue the case? That would be my assertion on that. Now, once again, 3 years from the time they filed their late motion and late answer, 5 separate attorneys that have worked on this case. 5 separate experienced, educated attorneys, and still have, only thing I can think of, have chosen not to comply with the rules. I believe that's all I have. Thank you for hearing me out.
All right. Thank you to both sides. We appreciate your arguments. Mr. Boesch, you may know the way the process works, but we'll take it under advisement and we'll render a written decision and send it to both of you at the same time. Okay. If you would, recess court till 1:30 this afternoon, please.
All rise. This court stands in recess until 1:30 this afternoon. Thank you.